First, in order to prove assault with intent to murder, prosecution must show evidence which would have supported murder had death occurred. That's first degree. They have to show that it was a first degree murder because they have to, in this, back up. This is People versus Sis Medea. That's 167 Mish 210. They have to show that that murder, that had death occurred, it would have been properly charged with murder. So second, let's go with People versus Todd, 186 Mish App 625, 1980. There must be an intent to kill in order for you to have, for murder. For you to have murder, there must be an intent to kill. And this is what the prosecution is no doubt going to argue. They're going to argue, you know what, even if he didn't say, I'm going to kill this guy, I plan to murder this guy. And you have to have that. You have to have plan and motivation to murder. They're going to say, well, he created a risk so high that, and he knew the consequence. He knew if he hit this guy, he could die, that's going to be sufficient. And I think would be the logical thing to argue, that the risk that he created with the knowledge of the probable consequence, that'd be sufficient. But the law would not support that. People versus Milton, 81 Mishap 515, 1978. There must be some time for premeditation and deliberation. So remember, the court may recall that it was 6 seconds from the time the officer got out of his vehicle and stood in that area in order to stop this vehicle from leaving. 6 seconds. Now, the law does not define how much time you need for planning and premeditation. It doesn't do that. But it is clear where there is no evidence of planning and motivation. They have to show that. They have to show some planning, some motivation to kill this person. What you've seen is a motivation to leave, to flee the area, perhaps. But there is no evidence put before this court that when this vehicle was driven at that officer, that the plan or the motivation, the intention or the premeditation was to kill anyone. And they have to show that. It's not enough that they show, well, it's likely.
But isn't that really a question of fact?
No.
As to whether or not
good question.
The evidence is sufficient.
Good question. Because People versus Oster, 67 Mishap says, where there is no evidence of planning or motivation, bind over is erroneous. So no, it's not a question of fact. And it's a great question, but People versus Oster has already answered that for us.
You've already said, have you not, that even though it's a 6-second time frame, that could be, or a fact finder could conclude that that is sufficient time for the premeditation.
Thank you.